Hello, I am Sam Young, a member of the Plan Giving team at Compassion and Choices. We are the oldest and largest nonprofit focused on choice and care at the end of life. Our vision is for everyone to chart their end of life journey. Financial and estate planning is a critical part of our end of life plan. We all need to ensure we have the right documents in place for our legacies, families, and heirs. Ricardo Thomas, an experienced financial planner, and his guests are going to focus on key information to assist you and debunk common myths. We are here to help. It is a perfect time for us to have this conversation since it's National Estate Planning Awareness Week. One thing we all know is that planning equals peace. Let's get started.
Thank you, Sam. And welcome to this edition of Focus On, where, as Sam mentioned, our focus today will be on estate planning and debunking many of those myths that tend to hamper our effective planning for our families and for our future. In today's session, I am excited to have with me a number of the members of the various leadership councils of Compassion and Choices. And I must say this, before we get into the heart of the discussion, I would be remiss if I did not first acknowledge the National Director of Community Engagement, who has been very instrumental in putting this together, Miss Brandy Alexander. Welcome, Brandy.
Thank you so much, Ricardo. And I just want to take the opportunity to thank our council members for coming on. We really wanted this to be an inclusive activity where we really talk about why planning is important, not only for our end-of-life care, but for our end-of-life finances as well. So thank you so much. I look forward to our discussion today. Thanks.
Thank you, Brandy. So as we said, our goal is to debunk many of the myths, and what we will attempt to do is get a perspective from the various council members by focusing on some of the key questions. And so as I call your name, we will allow you to pose your question, and I'll do my very best to give us a good answer with that, okay? So let's get started. First, representing the Latino Leadership Council, we have Jairo Guzman. Jairo, the floor is yours.
Good afternoon. I don't have a lot of money, so I don't need a will, right?
Jairo, if I had $1 for every time I've heard that question, we'd all have a lot of money here. So that is certainly a myth. And the reality is, regardless of where you live, regardless of how much money you have or don't have, you should have a will. Otherwise, you die in a situation that's called intestate, meaning that as opposed to your heirs or the people you specify receiving those things that you leave behind, by dying intestate, you are now introducing the court system into the process, and now a judge will be making that decision as to who gets what, as opposed to them following your wishes. So whether it's a small amount that I have or a significant amount, if I want to make sure that my wishes are being honored, it is absolutely critical, large or small, that I put it in writing. Having a will is essential. Now, again, depending on the complexity of your situation will determine how complex or how simple your will needs to be. But regardless of the amount, having it in writing with a will certainly goes toward that goal of keeping peace. Okay, Jairo?
Thank you.
All righty. Thank you. And so let's move on to our next question here. Mitch, representing the Asian American Native Hawaiian Pacific Islander Council. Mitch, the floor is all yours.
Well, thank you, Ricardo. You know, I think I'm too young to need a will. That's my question. Aren't I too young?
So Mitch, that's certainly a question that comes up sometimes. Folks will think, well, am I too young? Is it too early to start planning? Or possibly the flip side of that, is it too late? So let's talk about each of those parts individually. Is it too early? The answer to that is absolutely not, because the big question is none of us know when we're going to die. And unfortunately, we received a critical reminder of that over these last 2.5, 3 years as a result of the pandemic. And we saw, unfortunately, all around us, people of all different ages leaving here. So for that person, think about it. How often do we hear someone say, oh, I got time. I'm not going to worry about it. I'll get to it later. The age-old procrastination. Lo and behold, something like COVID comes about, the pandemic, and some of these folks who were accustomed to procrastinating and getting around to it later, well, later became now, and later became too late because nothing was in place, and you can't do any post-planning after you've left here. So certainly, as long as you're breathing, you certainly want to do that while you're in a state to do it, which leads me to the second part. Is it ever too late? And the answer is yes, because in order to do a will, in order to execute a power of attorney, or in general, in order to execute any type of enforceable legal document, you must be of sound mind. Okay, something that Compassion and Choices focus on, particularly with our resources on the website, is the subject of dementia. So let's think about that. So I'm still here, I'm still breathing, but I no longer have the mental capacity to make critical decisions or certainly take care of myself. So in a situation like that, if my family members are thinking about, oh, we should have a power of attorney on mom and dad or aunt or uncle or brother and sister, that person needs to be able to sign off. When you're speaking before a notary public or an attorney, they're going to repeat to you that the information in that document, and the key question they're going to ask is, do you understand what you are signing? Do you understand what is being included in this document? And if you cannot respond accordingly, then you cannot proceed with that document. And so the answer is, yes, it can be too late. One quick example I'll mention, going back to the pandemic, think about the folks who are now in the hospital. And, most of us are accustomed to being able to go into the hospital with our loved ones. Well, because of the sensitivity of the situation, we could no longer do that. And let's say now we're at the last minute trying to rush and get in there, but now because of their medical condition, they're not conscious. They can't execute a document, much less understand it. So in a case like that, absolutely, they were too late. So it's never too early, as long as you're breathing, but it can be too late if we no longer have the mental capacity. So Mitz, I hope that answered your question for you. And joining us today, I am happy to introduce Ms. Carrie Framstead, who is representing the LGBTQ+ Council of Compassion and Choices. Carrie, welcome to the program.
Thank you, Ricardo. My question is, my partner and my family, they already know my wishes. Is it still important for me to have a will?
Very good question. I've heard that oftentimes too. Oh, my family knows what I want to do, or my mom knows, so I'm not going to worry about it. And the thing is, I'll put it this way. Isn't it strange that when someone dies, and especially if there are significant assets, someone in the circle tends to suffer from selective amnesia? I'm sure we've all experienced that to some degree or not. Or another, at some point, where this person said, oh, absolutely, I'm going to follow your wishes, I'm going to take care of it, no problem. All of a sudden you're gone, and now they've forgotten everything that you've planned. So kind of going back to what I talked about with Mitz, it's important to have it in writing, because only then is it enforceable. Not only that, sometimes because of the fact that we say, well, oh, you know what, I'll make it simple. I'll leave it all to just mom or brother or sister, and then they can parse it out accordingly there. And then as a result of that particular situation, you end up with what I call the law of unintended consequences, where you mean well in an attempt to simplify things, but what you've now created is an adverse tax consequence. Because if it is in a will, or if you have specified these individuals as beneficiaries, it avoids the probate process. But if you leave everything to one person, and it certainly, if it's a significant amount, certainly over $15,000, then you may subject yourself to gift taxes, which could have been totally avoided if properly planned with a will, or when the situation warrants it, having the opportunities to specify beneficiaries, like on life insurance or retirement plans, or even bank accounts where you have the opportunity to specify beneficiaries. So it's not enough just to say that my partner knows my wishes, because again, unless it is a legal marriage where it's respected in that particular state, and we know it's not uniform across the United States, then perhaps your wishes will not be honored. It's not enough for them to know about it. You really need to have a legal document for it to be enforceable. So Carrie, I hope that answered the question a bit there for you. Good. So now we'll move on to our next question here. We have Reverend McNeil, who's representing the African American Leadership Council. Reverend McNeil, the floor is yours.
Thank you, Ricardo. My question today is that, I want to leave a part of my estate to a charity. What's the process of doing that, and how do I do it?
Thank you, Reverend McNeil. And that's a very important question. We know that many folks are philanthropically inclined, and obviously most of our questions so far today has been geared towards family and friends and making sure that our wishes are being honored. But at the same time, many people are also interested in giving back to their communities, giving back to the organizations that they are a part of, or organizations that they feel are doing good work in the community or world. And so one of the ways to do that is through proper planning, estate planning, and more specifically, planned giving to address these issues at the end of death. So now when we're talking about giving to a charity, you're going to hear a consistent theme here. You absolutely have to have it in writing. Otherwise, that charity will not get it. Now, that being said, when we're talking about doing planned gifts, or gifts that are kind of designated for end of life, one of the things we need to keep in mind is that really the planning should start well before death. And that's where all the benefits come in, depending upon the amount of assets that you're dealing with, depending upon the complexity of the situation. I mean, there are tax incentives for giving. There are ways to ensure that the organization gets those benefits when you leave here, while at the same time being able to still take care of your family's needs presently. So what it requires in a situation like that is working in concert with a financial professional and or legal professional who has expertise in planned giving and estate planning, sitting down and discussing what your wishes are, sitting down and asking the right questions as it relates to what are the ramifications to my estate if I give this asset or this property away now as opposed to at the time of my death. How does this impact my family? How does this impact the charity being able to receive it? By sitting down with a qualified professional before the time of need, and that's really kind of the underlying theme of all of the questions here. Let's get everything in place before the time of need, okay? I often say it's too late to buy car insurance after the wreck, okay? It does no good. The insurance company is not going to honor that claim. So same thing here. We want to address these issues before the time of need by sitting down with that legal expert, financial expert. And then oftentimes, depending on the significance of the gift, it may require bringing in that particular charity and their person, their expert, to coordinate with you so that things can be done properly. So that's a great way to do things. That's a great way to create a legacy. Many people want to do that. Many folks want to make sure, as I mentioned earlier, that the good work of many charitable organizations continues to go on even after their death. and by doing effective planned giving as a part of your overall estate planning charity is the way to do that. So Reverend McNeil, I hope that answered your question just a little bit there. So
Thank
with that, thank you. So with that, today our focus has been on estate planning. As we gear up for Estate Planning Awareness Week, we hope that with the questions that were posed by each of the members of the leadership councils, and again, thank you to all of the members that participated today. Those were great questions, and hopefully someone who's watching our session here will benefit from it, and hopefully it will motivate them to take steps so that things can be done according to their wishes. As we always say, planning equals peace. And there's nothing greater than having things in order upon the time of death. Now, as I close, again, I want to thank everyone, but also make everyone aware that there are many resources available on the Compassion and Choices website. We will have information up at the end if you are interested in finding out more about the planning process. If perhaps you are more philanthropically inclined and say, well, I like the work that Compassion and Choices is doing, and I would like to make a contribution to them. That information is available here on the site and will be available at the conclusion of this session. So again, to all of the participants, thank you very much. To those of you who are watching this session, thank you. Hopefully you got something out of this, and stay tuned for the next session of Focus On.